Okay, I think it's past our time, so I will start. Hello, everyone, and welcome to this Doughty Street Chambers webinar on the new EU human rights due diligence law and a review of the Modern Slavery Act 2015 update. My name is Krishnendu Mukherjee, and I'm a barrister at Doughty Street Chambers, specializing in business human rights and in immigration. The global COVID-19 crisis has starkly shown the interconnection between the concepts of human rights and environmental due diligence and the situations of modern slavery. Workers have been forced out of already poorly paid and insecure jobs, both here in Europe and also in Western supply chains elsewhere, and forced into the hands of traffickers and those who wish to exploit them further. We've seen this recently in the UK with regards to the garment factories in Leicester. This cycle of violation and exploitation is set not only to continue, but also deteriorate unless we deep dive into the root causes and provide accessible remedies. I'm proud to introduce Lucrezia Busa, member of the Cabinet for the European Union, Commissioner of Justice Didiers Reynders, and Dame Sara Thornton, the UK Independent Anti-Slavery Commissioner, who will both speak for 15 minutes each, after which there'll be time for questions and answers. I'm sure you're all used to the Zoom format nowadays, but for those of you who are new to Zoom and haven't attended a webinar before, you'll notice that your mics are muted and your videos are off. And that is a pre-existing setting, so please don't be alarmed. It just stops any background interference. Each speaker, as I said, will speak for 15 minutes, and there'll be questions and contributions, and we'll aim to finish by 7:30 on the dot. If you have any questions and comments for the panel, use the Q&A function on your screen, and I will make sure that they're directed to the particular speaker. If you have any comments you want to share with everyone on the webinar, please use the chat function. I will share your questions with the panel for them to answer during the webinar, and I may post them on chat too. And if we don't have time for your questions, we'll try and respond by email. We're recording this webinar, and a copy will be available on our website soon after we finish for you and any of the colleagues who are unable to attend. So thank you all for attending, and I would ask now Ms. Busa from the Commission to begin with her presentation. Thank you.
So good afternoon, good evening, everyone. And thanks for inviting me for discussing this discussion this afternoon about business and human rights and what we could do to improve the business model for a better protection of human rights. I should say that what I say today is exclusively my personal opinion. It doesn't bind the commissioner I work for, neither the commission as such. So it's just my thoughts based on my experience in the Commission. And I'm very happy to discuss with you an initiative that which the Commission is thinking, and I'm contributing to, which is a possible initiative on the control of supply chains and on corporate governance in Europe. I have to say that the initiative at this very moment is still into thinking mode. We are still thinking of how it should look like, how we should design it. So it's very preliminary, and today for me it's also a way to exchange ideas and opinions with you, and also learn a bit from your experience and from Mrs. Thornton's experience as well, and also see how what are the best lessons learned that I could use in my work and in my job. So as I was saying before, I would probably have more questions than answers today, but it's still, I think, even if it's a preliminary stage of the thinking we are in, it's still a good exchange for me to participate in this discussion today. So as already in the previous mandate, the Commission started carrying out some preparatory work, some reflections on the impact of our business model on human rights and the environment. The COVID crisis has further underlined and shown how our business model can create vulnerabilities in human rights, and in the environment generally, both in Europe, but also on a global scale. It has shown all the vulnerabilities that can derive from our business model, it showed also the scale and the urgency to act. The COVID crisis led millions of people across the world to lose their job, which might result in further inequalities, not only in Europe, but also across the world again, and might also expose people to situations where they are their workers' rights or their human rights might not be sufficiently protected. This is the thinking in which we are moving, and we are also in the Union a realization that there is a need to build a new business model that is more equal, more just, more sustainable, and also resilient. The COVID has also shown the consequences of the climate crisis, of deforestation, and the need and the consequences that this can have in our daily life, and also the need to act on this front. And there is a strong need also on one side in defending the planet, and on the other side ensuring that that we improve the impact that our business model has on human rights. The European Commission has recently proposed a recovery plan of an unprecedented scale. And in this recovery plan, the initiative on sustainable corporate governance has a prominent role. The idea being to build up a more sustainable business model, a more sustainable society. The issues that have been identified in our reflections and our preparatory work for the main challenges that have been reflected in our preparatory work for the realization of a more sustainable recovery are mainly two. The first one is the fact that a lot of companies, or always an increasing number of companies, focuses more and more on the short-term gains at the detriment of long-term gains, and the other is the complexity of value chains. The first one, the short-termism, has been highlighted by all the business community also, including some CEOs that have spoken about the pressure that from shareholders that pushes them to have a very often a very short-term perspective. And also data that were collected also by different researchers show that the proportion of revenues of the companies that is allocated to R&D or to more long-term projects has been declining over the last 30 years, whilst the large part of the revenues has been rather used for the shareholders' remuneration. This has also an impact in the investments of the companies that the company could do, for instance, for better protection of the environment, and more generally for a choice of the company also on how to best organize its production process in a way that takes into account also the interests of the workers and the communities that are impacted by the company's activities. At the same time, the other big challenge that we have encountered is the need to control the supply chains. Supply chains are getting of a global scale, they are larger, they are more complex. And for many companies in Europe, it becomes more and more difficult to have a control of what happens throughout the supply chains. And therefore, they may be exposed to the fact that in that part of their supply chains includes also companies or actors that do not respect the environment or do not respect human rights. So our challenge is to tackle these two issues And the reflection for the time being is to do that through an instrument of company law and sustainable corporate governance. Our corporate governance reform would have three main objectives. On one side, to foster long-term horizons in corporate decisions making, incentivize sustainable business models, and increase also corporate accountability for human and environmental harm. Now, how to do that? We have two main actions that we are thinking of for the time being. The first one is to clarify directors' duties, corporate directors' duties, in a way that the duties of the directors will include also the obligation to balance stakeholders' interests with those of shareholders. And when we speak about stakeholders, we speak about the workers, we speak about other people that are affected by the company's activities, and as well as also the environment that could be affected, that is impacted by the company's activities. The idea is that the directors should integrate sustainability risks and impacts into the corporate strategy, and there should be in the company also some processes to make sure that directors achieve such objectives. This could be linked to the remuneration or to the way the board is constituted, etc., or to procedures, other form of procedures within the company. On the other hand, we were thinking about a due diligence obligation. There would be a mandatory due diligence and would apply across the sector to the different companies. And the idea would be that the companies puts in place some processes, again, that would allow the company itself and the board and to identify, to be aware, first of all, of the different steps of the supply chains, and to control also what happens throughout the supply chains. There would be also a mechanism of reporting, and that would allow also a certain transparency in terms of supply chains. This is what we are thinking. The inspiration has been the UN Guiding Principles on Human Rights, the OECD work, and also some national legislations like in France or in UK, and some thinking is also being going on in other member states like Italy, Spain, and Germany. And the idea is on our side to avoid also market fragmentation in the EU, to have a European instrument. We have commissioned the study already that has been, to which more than 600 stakeholders participated, and that included a lot of businesses and other NGOs and other entities, and included a large sample of stakeholders across the member states. We know that the businesses, many of the businesses who responded put forward the fact that they have some processes already, especially to control their value chain. And they also said that these processes have allowed them to weather better during the crisis, to face better the consequences of the crisis. So there is also a value added for businesses to put in place these processes. On the other hand, the studies of the result of our studies show that only 1 out of 3 of these companies has put in place such processes, and that voluntary action might not be enough. There may be a need for mandatory action. So the question is how to, for the time being, that's what we are reflecting on, how to design such action. The other considerations that have been put forward in our studies were also the need to level the playing field compared to other countries, third countries, and also how to take into due account the burden, the administrative burden for companies, in particular for SMEs. So this is one of the questions on which we have to reflect, how what to do for the SMEs, how to take into account the fact that they have a smaller size, and because of their size, they may have a smaller impact on the environment, for instance, on the communities around them. In terms of cost, the study has also shown that the cost would be a minimal percentage of the revenues, and the competitiveness and the potential effects of competitiveness vis-a-vis third countries would also be limited. But again, this is one study. We still are into, we will do another one that has to be published in May. Had to be published in May, but due to the COVID has been delayed. It will be published hopefully before the summer. At least before August. And then we also plan to launch a consultation, an open public consultation to the different stakeholders, and our idea is to do this as soon as possible, and to involve the largest number of stakeholders. This would allow us to collect all the input from the different views, different actors, and to take that into account to better shape our initiatives. There are a number of questions that we have to reflect on, like how the companies could control the other companies in the value chains, what could be the obligations that we have to impose, and what would be also the transparency, if anything, etc. And so the ultimate idea after the consultation, there will be an impact assessment to evaluate the consequences of the initiative for the various stakeholders. And at the end of it, there will be a proposal. The idea, preferred option, is to possibly put forward a legislative proposal, if that is confirmed by the impact assessment and by the feedback of the consultation. And this, as I was saying, this would have a horizontal application, and could be then complemented by more sectorial initiatives that could be also of a non-legislative nature, and could also include cooperation with the industry, and also initiatives that have an impact also on third countries. So that would be also brought more in the framework of trade instruments. The idea is to have our initiative as an umbrella, and then be completed by possibly other initiatives also in the field of environmental law or trade law, that would constitute therefore the complete approach from the Commission to this question. So as I was saying, happy to answer your questions, but also happy to ask some on my side. Thank you.
Thank you very much, Ms. Busa. That's a very good introduction to the EU Commission's thinking on how we build back better after COVID, and your findings on voluntary provisions for due diligence. And with that in mind, I turn to Dame Sara Thornton, who may wish to speak about that, but also in relation to the other review of the Modern Slavery Act as well. Thank you.
Thank you very much, and good evening, everybody. By way of introduction, my role was established by the Modern Slavery Act 2015. It's an independent role, independent of government, and my role is to encourage good practice in the investigation, detection, prosecution of Modern Slavery Act offences, and also the identification of victims. And so kind of preventing modern slavery is a key part of it. So I will look forward to a debate on the issues that Lucrezia has just been raising. I'm particularly interested to see how this European Green Deal is debated, and this whole kind of sense of mandatory due diligence for both the environment and for human rights. What I thought I would do, before diving into all those issues of prevention and supply chains and human rights, I thought I would just give the quickest of overviews about where I think we are under three headings. The first is supporting victims and survivors. Second is law enforcement and prosecution. And the third will be that focus on prevention. And I will comment on the issues around Leicester. So in terms of supporting victims, what I've seen in the first year is, many more victims identified, great support from the caseworkers, the people who work in the charities and organisations on the ground. But I have been amazed at the way in which victims are caught up in this bureaucratic system where they're waiting sometimes for years for decisions about whether they're a victim. I don't know that we treat any other victim of crime in that way. And it just looks to me like an immigration casework system, which is centralised and very slow. So as I've met many victims and survivors, that sense of people's life being on hold and therefore what needs to be done is a key question. I've come to the view that support for victims needs to be much more local and decision-making much more local. It's not straightforward to try and establish new systems, but I'm working with colleagues at the moment with some of the children's charities to think about what a local system for children might look like, so that the decision-making is made locally alongside the interventions, the care and support that's provided to children. And my sense of it is that we are better than we were at that sort of immediate rescue. It's not perfect for exactly the reasons that I've said, but I have seen good work. But the second concern I have is that I don't think we're doing enough to help victims to become survivors. So whether that's issues of access to training, to education, to work, their status in the country in terms of their immigration status, housing, accommodation, a huge number of issues that my team and I have been kind of probing and pushing, because I do think that we need to establish much better solutions, much better responses, if we really are going to help victims to become survivors and lead lives of sustainable independence in the way that you and I would take for granted. The second issue I was just going to touch on is law enforcement, because clearly that's a key part, going back to Palermo, the importance of prosecution. And what has struck me is, on the best cases, how gaining the confidence of victims is absolutely essential. And to think of victim support and law enforcement, or the kind of protection of victims' human rights and law enforcement as two separate things, they often and should be, in my view, deeply interconnected. So gaining the confidence, making sure that frontline responders know enough to give proper advice and assistance and help is really key. And what struck me looking at the data, police forces and indeed the National Crime Agency and the Gangmaster and Labour Abuse Authority are all carrying out more operations, more investigations. But the ability to convert that into prosecutions is really very weak. The numbers of prosecutions have gradually increased if you take a view that we count prosecutions as general offences which have a flag to say they have a connection to modern slavery. If you use that approach, they have crept up to 349 last year. But if you actually look at prosecutions under the Modern Slavery Act, Section 1 and 2, and if you remember going back to the Act, that whole point about rationalisation of complex bits of law that was everywhere in various acts was a key objective as far as I recall. Actually, the numbers over the last few years, in 2017-18, 124 prosecutions, 2018-19, 89, and in the first 3 quarters of 1920, 54. So unless the last quarter was really, really active at the beginning of this year, then I suspect that the number will be going down again. And this is an issue which was raised, I think, very forcibly in the Centre for Social Justice report, which was published today, and to say that actually we are not doing anything like enough to bring traffickers to justice, and that sense in which they will continue to see the rewards as high as the risks as low if we don't do something about that. So the focus on prevention, and very much the focus of tonight, and I think it's just worth saying something about Leicester. And we were explaining to Lucrezia before we came online what was happening in Leicester, because clearly she would be less aware of it than we would. But I think it's one of these examples where COVID has just revealed so much more starkly pre-existing issues. It just puts it all into sharp relief and focused on something which has been there for quite a long time. And I'm much persuaded by the argument that with labour abuse, you've got a continuum, which would start maybe at non-payment of sick pay or holiday pay or the national minimum wage. Maybe people have to pay for their uniforms, and going all the way through the scale, ending up with the most egregious forms of labour exploitation, which of course are criminal offences. And so you have that kind of continuum of abuse. And what happens, I think, if the compliance issues around non-payment of wages are not dealt with properly, if the issues about health and safety, about employment contracts, all the issues that have been repeatedly raised are not dealt with, then it's a perfect environment for modern slavery and human trafficking to exist. And I was looking again at the 2017 report, the Joint Committee on Human Rights, which actually had been to Leicester 3 years ago. The Environmental Audit Committee had taken evidence about Leicester in 2018. The University of Leicester had written a report in 2015. We've known about this for a very long time. And it's not true to say nothing has been done. I saw some data last week that suggested that there have been 300 operations in the last 3 years from various different agencies. But actually, whatever they've been doing, it's not been effective. And so we get reports in the Guardian, the FT, the Sunday Times, the Times, about real concerns about what's happening. And of course, COVID highlights it, because the concern is, of course, and this is linked to, businesses that don't care about paying their staff the minimum wage, don't care about their health and well-being either, and therefore make them particularly vulnerable to this pandemic. So why is it that this has proved to be such a stubborn problem? And I was just going to talk about some operational issues, and then I will go into the legislation, which hopefully will bring us neatly into the issues of human rights due diligence and the sorts of issues that Lucrezia was just raising. So in terms of why, I mean, one of the problems with somewhere like Leicester, and Leicester, to be fair, is not alone. There are issues like this in London, in Manchester, and in other areas where the textile industry operates in the UK. Lots of different offences and lots of different organisations, all in these institutional silos having different responsibility. So whether it's health and safety, whether it's HMRC, whether it's the local fire brigade, whether it's the local council, whether it's the police, whether it's the Gangmaster and Labour Abuse Authority, a whole range, the National Crime Agency, a huge amount of organisations. And that is a kind of classic situation where actually everybody thinks somebody else is doing something, and it's so easy for interventions to be ineffective. And I saw last week there had been a lot of enforcement activity, but I was left wondering who was in charge, who was leading that, because it's far from clear. But the second thing that I think makes this quite a stubborn issue that I wanted to draw attention to is that, of course, we have people who are affected, victims of maybe trafficking and slavery, but certainly of labour abuse, who have no confidence in the system, who have no power really, they're desperate people very often for whom £3.50, £4 an hour is the best option they've got. They are making a rational decision in the circumstances in which they find themselves. And it strikes me that very often when you listen to the organisations who are charged with enforcing, with dealing with these abuses by employers, that it's quite a reactive approach. So they wait for people to complain, they wait for people to bring forward issues. And if people don't trust the system, if they feel powerless, that's just not going to happen, not least because there might well be all sorts of language barriers. So I talking to organisations over the last few weeks saying, to what extent have you tried to work with grassroots organisations in the communities, with the trade unions, to try and kind of build a picture, to build confidence so people feel able to make disclosures and to be whistleblowers. So it is a really intractable problem. We have got an opportunity now. This might end up being a signal event which really causes a lot of pressure, certainly pressure in the system for more enforcement to be done. And I think, there are ideas about having a really locally based task force, and maybe to test out some of the ideas of the new single enforcement body, which is a proposal that government had in their manifesto, and it's about bringing together the Gangmaster and Labour Abuse Authority with the people in HMRC who look after minimum wages, with the people in the Department of Business who look after employment agency standards. And if you could have a kind of a locally based organisation which was really focused on that, working with whether it was the police force or other organisations locally, the local council, if you had that sort of field force on the ground, would it make a difference? So I think there are big operational questions to be asked. But then let's go look at legislation, because that's the obvious thing that Lucrezia was talking about. Section 54, I think, was groundbreaking, but it was light touch. And if you look through Hansard and the debate that was had in Parliament, it was proposed during the course of that legislation through Parliament. But I think, in hindsight, we would say it's quite light touch, which is why the independent review last year said it needed to be tougher and the sanctions needed to be greater. All the requirements for the statement needed to change from may to must, that it shouldn't be possible to say that there was no slavery in your organisation and therefore that was it. That actually the fines should be gradually increased and the bar raised. And they talked about linking into company directors' disqualification. So it's really vital, in my view, that government responds to those. I understand that that is imminent, but you had an independent review saying, actually, this needs to get tougher and tighter, and I would support that. And I think we need to see what we can do to make what we've got more powerful. But then what we've been listening to tonight, sort of based on the UN principles on business and human rights, looking at a kind of a human rights due diligence approach as part of the European Green Deal. So of course it would go beyond TISC and look at human rights due diligence right across the board. One of the questions I would have, which I think is an interesting debate, and I was listening to Harriet Harman at the weekend talking about this on the radio, about should companies be made responsible for all the human rights abuses in their supply chain, not just should they be mandatory human rights due diligence, but actually what if something's found. And I think that's a really interesting kind of part of the debate. But the other thing that I just thought is worth mentioning, I kind of always intrigued by whether you try and make what you've got work better or whether you kind of move on to something new, which would be human rights due diligence. And of course, the obvious model, and Lucrezia mentioned it, is the French model, which of course we know that catches very, very many fewer companies than the UK model. I think the French law, I think it's something like 250, 300 companies. The UK law covers 18,000, so it's very, very different. And I know UK levels of compliance aren't great, but I know they're only about 30% for year one in France. So there is a different model on the table. And I think three kind of comments on a kind of compare and contrast. The first is that I've often heard it said that it's really important that we have the due diligence because it's very obvious it's got to go right down the supply chain. But in fact, there's nothing in Section 54 which suggests it's only in Tier 1. There is a view that that's the practice, but I can see nothing in the law which suggests that it's in your supply chain. It doesn't kind of specify a level. And of course, the term due diligence is actually used in the guidance, and it talks about companies doing due diligence in respect of their supply chains. The important change, of course, is around remedy. The only, well, there is no remedy really in terms of, sorry, excuse me, my partner's trying to get into the house. No, you have to go around the back. Sorry. There is no remedy in terms of the transparency in supply chain. What you've got is a very kind of light power of the Home Secretary to injunct a company to require them to write a modern slavery statement. And that's a power that's never been used. So I think there is a huge difference in remedy. And I know in the French model, of course, NGOs are allowed to take action. The UK model, the TIS model, just has that very limited power for the Home Secretary. And the last thing that I think, and maybe this is, you could say it is part of TISC, or it could be part of TISC, or it could be. But I think that sense in which human rights due diligence implies companies doing much more to deal with the kind of the adverse impact on workers, on people, and it implies more engagement in a way which I think is really very helpful indeed. And I'll just finish by saying that last month we published a report on Operation Fort and what businesses should learn from that. Operation Fort was a massive labour exploitation case, 400 victims from Poland working in farming and in fence making and shed making, Tier 1 suppliers for all the main supermarkets and DIY stores. And what we did was I wrote to all the companies, we met with them, we looked at their modern slavery statements. And I think we came to the view that that sort of requirement for a statement for reporting was just the kind of the foothills. That was the very basic requirement. And what we were really attracted to is the companies, and we said they were the best, that were really leading in human rights innovation, that were thinking about worker engagement, that were thinking about the cost of labour, that were thinking about advanced data analytics, and that were really focusing on working through their supply chains and cascading ethical standards. And on that, I'll finish. Thank you.
Thank you very much, Dame Sara. Plenty to think about and plenty to consider. I've got two questions for each at the moment. For Lucrezia, two questions from the audience. First of all, in terms of the consultation, I mean, obviously we know that, as you said, so a lot of these supply chains, most of these supply chains from which there's most severe environmental violations end up in countries with the most human rights violations. What are you intending to do consultations in some of those countries in order to gauge, for instance, the levels of workers' pay in those countries, and whether those levels of pay in supply chains would violate human rights norms? And the second question for you is in relation to financial institutions. Are you intending to, because as we know, financial institutions, banks, pension funds and so on invest in industries quite often abroad, which commit human rights and environmental violations, and are largely unaccountable under the present regime? Are you intending to bring financial institutions under the umbrella of mandatory human rights due diligence as well? And are you consulting because of that? And then for Dame Sara, perhaps I can just ask your questions at the moment and then we can answer them in turn. So the question about how do you speed up the decision making for victims of trafficking? I understand that people are waiting now 6 months for a reasonable grounds decision and sometimes 2 years or more for a conclusive grounds decision, and that is, as you say, unacceptable for the victim and acceptable for the in terms of redressal or criminal sanctions against the traffickers. And the second question for you is, what do you think, or what would you say was a single most effective way to combat the kind of violations that we see in Leicester? If you could have a wish list of one thing, what would be the most effective way in which that could be dealt with? So perhaps I can ask Lucrezia to start off.
Yes. So on the first questions on the consultation, the way we normally do consultations is that we have a list of questions on our website, and whoever can reply to these questions. The aim is to go beyond the usual suspects who reply to a commission consultation, meaning like the largest companies or the largest NGOs as well, so to reach the widest number of stakeholders. Your question was whether we plan also to listen to also to target third countries, especially in those in which the human violations are the most flagrant one. So we are not going to proactively send questionnaires to these countries, but of course those who will reply to our consultations will include also NGOs who are active in a number of countries who deal with these issues. They are very aware, and they will bring these issues. At the same time, we are also doing a fact-finding, also using the expertise that the colleagues who deal with development issues have, and also the knowledge that they have because they are in some countries and they can contribute to us, and we will take that into account when forming a view or how to shape our initiative. And the same also for the colleagues who work in the trade department. And the Commission also has delegations in the different member states, in the different countries, third countries, and they are also they will also provide to us their knowledge of the facts in the different countries. So all these different contributions will be taken into account. We cannot go directly to third countries and ask, but of course the people who reply, especially the entities like the NGOs, are able to provide us information, and also our internal networks of delegations and of administrations within the Commission work on cooperation can help us on that. And on the second question on financial institutions, this is one of the questions we will reflect on, how to design and the initiative, and how to cover, when speaking about across sectors, how to involve the different companies active in the value chains, including from a financial investor point of view.
Thank you. And before I just turn to Dame Sara, perhaps I could just clarify what the timeline is for these consultations, because it's important that people, I think, know what timeline we're looking at.
It's normally 3 months, but
when do you envisage ending the consultation, I suppose, is the best question. Yeah.
Okay. The first question is, when do we start? So we will try to start by end of this month, and if not, there will be immediately after the summer. So, sorry, when I speak about the summer, I take the Italian perspective, which is normally August. But so if not end of the month, then it will be beginning of September. And
the consultation will
yes,
be about 3 months.
And then from that, it will be running for 3 months.
Okay, and the questionnaire or whatever will be widely disseminated so that people can have the full.
It's on the European Commission's website.
Okay, all right. Well, because I do find sometimes there can be a sort of slightly European-based conversation, and having worked in India for some time, it's really important, I think, that those views are also heard from those countries. But thank you for that. Dame Sara, can I ask you to come back on those questions? You're muted, Dame Sara. You have to unmute.
Sorry, schoolgirl error there. Just to be clear, on the reasonable grounds, the vast majority are done within 5 days, but there are occasional outliers that take a long time. But I completely agree about the conclusive grounds. In terms of, if you were asking what can you do as an individual who is maybe advocating on behalf of a victim, I suppose you can just do all you can to put pressure, whether you kind of write to them, I don't know whether you can raise it with your member of parliament, you know, for them to write a letter. Sometimes that can work and push a bureaucracy on. I think what I can talk about though is what I'm doing. I meet the Home Secretary regularly, not often, but regularly, and we always have talked about this as one of the issues. There is the power of my voice. My annual report, which will be laid before Parliament in September, will comment on this yet again, and I have frequently raised it in the media. The Home Office now are looking at a transformation of the whole system. The last change programme was meant to deliver faster decision making. It has not. In fact, probably things have got worse. But I think there is an acceptance now that the system is just not working. It is what it's being asked to do has changed so much over 10 years, and a kind of complete transformation needs to be assessed. It needs to be addressed. It's very, very early days. My consistent message to the Home Office as they think about what that might look like is, you must include the people who are involved in this process, the victims and the survivors who have lived experience. And we must make sure we build it kind of bottom up, informed by practice, rather than sitting in an ivory tower. In terms of the second question about what one thing can I have in Leicester, look, given there's an enforcement issue, it's a scandal, isn't it, that the newspapers keep going into these factories and very, very quickly getting evidence of complete violations of laws on minimum wage and laws on health and safety. So I think we need a well-led task force to enforce the law, but with a really, really strong emphasis on community engagement. And people are going to have to think of quite imaginative, thoughtful ways to build confidence with workers, because it's not straightforward, but it absolutely needs to be done.
Thank you very much. We've got a lot of questions. We can't answer them all, but I'll try and circulate them afterwards. So one question for Dame Sara and one question for Lucrezia. The question for Lucrezia is, what are the types of sanctions which envisage may be included in any legislation where businesses have abused human rights and had severe impacts? What are the range of possible sanctions which are being contemplated, I suppose? And the question for Dame Sara is, we can see that slavery impacts on both those with or without status in the UK. Do you think the government needs to do more around poverty reduction, which is one of the main drivers into slavery? And if so, what? And I think we've got time just for those two questions at the moment. Lucrezia, do you want to answer your question first? You're on mute.
Yes. Okay, so for in terms of sanctions, we agree that something that is very important is the enforcement of the mechanism that we put in place. What we are looking at is, we are looking at different ranges. What has been done in different forms of sanctions. What has been done is in the past is civil sanctions, civil law sanctions. So I think in the UK would be tort, and as a possible, this could be a possible way of enforcement. It could be also administrative sanctions with the supervisory authority that is responsible for that, or it could be a combination of both. it depending also on the kind of issue, on the kind of problems, and on the way in which we design the system.
And in terms of the question, I've done a little bit of work recently on economic insecurity, and it's an issue that is increasing across the developed world. And this sense in which people just don't have confidence that they can provide for themselves. They're not confident about their economic future. They're not confident that if there was a minor economic shock, if they had to pay a bill of £100 or £500, they just would not be able to do it. And this is a real concern. And I think that forms part of the backdrop to people, and particularly in the kind of during this pandemic, people have lost their jobs, feel increasingly that they are drawn into exploitative work because they have no other option. And that actually it ends up being a rational choice. And I think then we do need to do much more about economic insecurity of a wide number of people, whether that's people in the gig economy, people who are migrant workers, people for all sorts of reasons. Their position they feel is fragile and insecure, and they are therefore, I think, much more vulnerable to trafficking and slavery. And so I think, yes, we do need to do more.
Thank you very much. And we don't have much time, but maybe one more question. So one of the movements that was happening anyway, even before the COVID-19 pandemic, was that supply chains were becoming more localized. And that move is, I suppose, going to accelerate. With the implementation of possible mandatory human rights due diligence law and sanctions, as you've described, do you feel that companies will be increasingly trying to boycott countries with the worst human rights records and environmental records, and that will bring supply chains more local? Do you think that's something that'll continue and increase?
I think the choice of localization or the movement, the ask for a localization, has been more prompted by other considerations, and the fact that, for instance, there were some shortages, difficulty to supply certain products during the COVID, etc. What would be the impact of the sanctions or of the system itself? I think our idea is, first of all, to ensure that the companies are accountable and responsible for what they do. Then the question of how this will, hopefully, let's say the thinking is that hopefully this will translate into them influencing in the way other countries, the situation in other countries, in a way that in these countries workers' rights and human rights will be more respected. We are not doing this to sort of move away from certain countries the possibilities of for people to access a job. The idea is really to create a spillover effect, so that also in other countries human rights could be better respected and defended.
And sorry, and just, will Brexit make it more difficult to do that?
I cannot reply anything on Brexit.
All right.
Can I choose one of the questions? Is that allowed?
Sure, if there's a question you really want to answer.
Well, only because Tom Wells said that I had asked whether businesses should be held accountable for the human rights abuse in their supply chain, but didn't offer a view. For me, the fact that we can't even enforce minimum wage law or health and safety or contracts or basic stuff, I would say we need to get that done in suppliers first. And at the moment, I'm not yet convinced that making companies responsible for everything in their supply chains is the right answer. But you know, let's do the basics first, and let's have a conversation about that. It seems to me that human rights due diligence requires the due diligence. Whether it then leads to an accountability for everything that might happen in your supply chain, is that setting the bar at a level which is just not reasonable? I think interesting debate to have. So at the moment, I'm not convinced. I haven't seen the evidence, but really up for the debate.
Thank you very much. And it's now practically 7:30, so we'll have to end there. I'd like to thank, first of all, Ms. Busa and Dame Sara Thornton for being the panelists for tonight, and for all of you out there for listening and contributing. We hope to have further business and human rights webinars from Doughty Street Chambers in the near future on this subject and other related subjects. So please keep an eye out for that. And I really hope that you all keep safe, and that we look forward to a better future. Thanks very much. Bye.
Thank you. Bye.
Thank you. Thanks.